was that the court did not make an order.
Sorry, the court did not make an order.
That's why the registry didn't want to release the passport to him.
So it will be mentioned on 12th of March. Unaweza enda wameweka order utachukua passport.
Yesinda Wanjiru Barack Obama Oleo.
Of an arrested person, he can remove that thing. He's just creating unnecessary drama. Orders against him for 10 days for the police to enable them here verbatim for brevity of this ruling occasioned by time constraints, but in the main the respondent he seeks to detain the respondent to conclude his investigations on the crimes that he's investigating him for. And he argues a Mote advocate, and your arguments essentially, to paraphrase, are that the police, in this case the respondent has been arrested first before they commence investigations, whereas they should have concluded the investigations before arresting him. And it has not been shown why the applicant, and it has not been shown whether his detention is really necessary to conclude those investigations. Remanded in custody, and it has always been this court's position to only grant such an order for pre-charge detention where there is no objection. You have met the criteria of granting such an order, and it's a legal burden that must be discharged, bearing the relevance of the doctrine of stare decisis, vertical stare decisis, the judicial precedents that bind these courts on the requirements that need to be met by the state in their quest for pre-charge custodial orders against a respondent, being 4 cases: the case of Michael Rotich versus Republic 2016 EKLR, Betty Mutai Kimeiwa versus Republic 2018 EKLR, Oscar Kipchumba Sudi versus Republic 2020 EKLR, and Michael Juma Oyamo Court of Appeal case 2019 EKLR. And the conditions that have been set there that I need not repeat in the ruling, and surmise that it's really indeed an onerous task to convince the court as to merits of such applications, having consciously, I'm talking of the investigator having on a police bond or bail pending conclusion of the investigation, as the onus was on the police to demonstrate why the respondent in this case should be denied his constitutional rights of bond, bail, which are specific to him, bearing in mind that the offenses that he's investigating are bailable under the Constitution. And when you look at the affidavit that he has filed in support of the case, it is apparent to me that the applicant, the investigator, has prima facie evidence of the charges that he intends to prefer against the respondent herein, and therefore the applicant had to avail to himself the guidance of the superior courts in the case of Michael Rotich, and he has not even demonstrated whether there was any difficulty in arresting the respondent. In fact, he was arrested when he was meeting the complainant, and he has to pose in conclusion this question to himself, whether he has provided any compelling reasons to satisfy the court as to institutional guarantee, as to right to bail. The case of Michael Juma Oyamo illustrates the definition of a compelling reason, especially for rights of an arrested person. I noted the argument by the prosecuting counsel concerning the amount of money involved in this case, 40 million shillings being a colossal amount, but that alone cannot be a consideration to deny the respondent his constitutional right to liberty. He has not been accused of any crime. I think that is worth stressing. His rights, therefore, are that of an arrested person and not an accused person. And even if he had been accused, had he been an accused person, he still has the right to be presumed innocent. The avenues that have been provided by the law, he should have availed a a holding charge against him, and just so the state can be accommodated without the radical measures that are being sought by the applicant or bail. But I shall listen to submissions on that question of bond or bail before giving further directions on the same. Okay?